Hi, everyone. I'm Tariq Habash, the Head of Investigations at the Student Borrower Protection Center. Before we get started, I wanted to take a quick second to thank you all for joining for the final installment of our Emerging Risks virtual conference series. If you had the chance to tune in the past couple of panels, you would have likely heard from some of the foremost experts on consumer protection and the applicability of federal law on income share agreements. Today's panel continues along that trend, looking at income share agreements from the state perspective to understand the applicability of existing legal and regulatory frameworks. I want to thank all the panelists for participating in today's conversation. If anyone watching has questions that they would like to ask our experts, please email those questions to walter@protectborrowers.org, or you can post them on Twitter with the hashtag ISA Emerging Risks. Although today is the final panel of our conference series, videos of the ISA panel discussions, as well as our report series, will continue to be available on emergingrisks.org, and we encourage you to explore these resources and reach out to our team if you have any questions. Thank you so much and enjoy.
All right, thanks, Tariq. Hi, everyone. My name is Jillian Berman. I'm a reporter at MarketWatch, where I cover higher education and student debt. First, I just want to say thank you so much to the Student Borrower Protection Center for having us all to talk about this important topic, income share agreements. These financial products that allow students to finance their tuition by pledging a portion of their future income have attracted controversy and also gained traction over the past few years. And so it's really, great to be having a conversation about them. As Tariq said, this is the third in a series of panels. The first two were about the market more broadly, and the second was about fair lending implications for ISAs. If you want to see those, they are recorded on this website that you are now viewing this panel on. Today, we're going to talk about state implications for regulating ISAs, and we have a group of experts who have a lot of experience in the consumer protection space, student finance space, and they're going to share their expertise. First, one of those panelists, though, is going to tell you a little bit more about the applicability of state laws to ISAs. His name is Ben Roesch. He's an attorney in Jensen Moore's Baker's Seattle office, and his practice is focused on student loan and insurance coverage advice and litigation. He also worked on student loan issues in the Washington Attorney General's office, including their litigation against student loan servicer Navient, and also in helping to bring the student loan borrowers' Bill of Rights in that state to fruition. So let's turn it over to Ben.
Thank you, Jillian, and thank you to the Student Borrower Protection Center for the opportunity to present a paper and participate in the panel. One other thing before we jump into the paper, I really need to thank a former fellow at the Student Borrower Protection Center, Hillary Marston, who contributed a great deal to the paper and deserves recognition for that. My paper really kind of picks up on some of the same questions that were previously examined by Brian Shearer and Joanna Pearl in their paper about the applicability of TILA, ICOA, and other federal consumer financial protection statutes, and asked some of the same questions about educational ISAs in the state law context. What I found was that there are a number of state laws that apply to educational ISAs sort of throughout its life cycle, from marketing to potential borrowers, all the way through collection in the event of a default. It's worth breaking down these laws into two broad categories. I think the first are what I would call laws of general applicability. These laws don't apply or not apply depending on whether ISAs are credits or loans under these statutes. These are statutes like state consumer protection acts that bar unfair or deceptive acts or practices, and state laws that regulate the collection of defaulted obligations. They apply for the most part regardless of whether the underlying obligation is a loan or sort of an overdue bill, that sort of thing. The second category of cases is kind of more interesting. I think it's probably why most of us are here. And those are state consumer finance laws whose applicability depends on whether ISAs constitute loans or credit under state law, whatever the applicable term might be. There are a variety of state laws that address these issues. But I think as we look at them, we need to come from a sort of historical understanding of this debate and how it played out about 100 years ago. Back in the 1920s and the 1930s, another group of lenders, they're called loan sharks back then, we call them payday lenders now, sought to avoid state usury statutes by characterizing their products rather than as loans as the purchase of wages. Sometimes those wages were already earned, sometimes they would be earned in the future. And the policy consensus that developed was that these products operated like loans and they would be regulated like loans. We still see, about 100 years later, laws on the books explicitly stating that the purchase or assignment of future earnings or wages is a loan and will be regulated as such. So that's one category of cases, or one category of states. We've got two other categories, and we've got one category in which we don't see the sort of statutes that I described on the books, but we have sort of an explicit definition of loan. And I think in most of those states, educational ISAs generally fall within those definitions. And finally, we've got a number of states that don't define the loan at all in their consumer financial statutes. And there we look to questions of what was the legislature's intent when they enacted those statutes. And that can be determined from sources such as legislative history, but also the common use and dictionary definitions of the terms that they used, such as loans. And I think that ISAs generally fall within the common usage of loans, where the borrower receives money in exchange for a promise to pay money back in accordance with the agreement. Most of the time, the borrower is going to pay back well in excess of the amount that was borrowed. And I think that's really key, as, for example, the Colorado Supreme Court found in determining whether ISAs are in fact loans. So this raises a whole bunch of issues on how various state laws then apply. These can include licensure requirements for ISA providers. In states that have student loan servicing legislation, that can include conduct standards and licensure for the entities servicing ISAs, as well as usury and other state laws. So I guess with that, I'll pass the baton back to Jillian, and we can get into some of these questions. Thank you.
You're back and excited to talk. So I'm gonna, just throw a question to each of you, and when you answer, if you could please introduce yourself. So your name, what you do, and kind of how you come to this topic. That would be great. So first, we're gonna start with Joanna. And Joanna, I know you and I have talked a lot about this, in phone conversations, but I'd love to hear for everyone. What are some of the things when we see how ISAs, describe themselves or the products that they're offering, that concern you about the way that they talk about themselves and present themselves to consumers?
Hi, I'm Joanna Darcus. I'm a staff attorney at the National Consumer Law Center, where I focus on student loan issues, and I also do complex civil litigation. I was introduced to income share agreements when I was a legal aid attorney back in 2015, when this topic was just starting to come up all over again. It's not new, but it was newly launching and in the higher ed space. And when I joined the National Consumer Law Center in 2017, ISAs were still a hot topic, and here we are 2 years later still talking about them. Along with my colleagues who focus on all different kinds of areas of consumer protection and consumer debt, we've been doing some research on income share agreements and the implications, both in the higher education space and more broadly. We've seen ISAs in other sectors of the economy, as well as personal loan replacements, for instance, and have really been looking at the ways that federal law and state law interact, and also provide a framework for regulating income share agreements. For those of you who are state regulators, I hope that you are already looking into income share agreements and applying the tools that you currently have at your disposal to learn more about the income share agreement industry and to rein in the predatory practices and concerning practices that we already see. Among those practices are several things that you're going to hear a lot of us talk about and that you've probably already heard, including what Ben presented in his paper. And this is one of the places where I hope that you'll understand that it's really important to distinguish the industry rhetoric from reality, and to set aside the claims that the industry makes and the definitions that they choose to hold on to, and look at them rigorously and look at the nature of the transaction, what's really going on here. So some of the things that have been concerning for us are that in general, ISA providers don't call themselves lenders, they don't call themselves creditors, and they don't want to be viewed as such. They also, ISA providers that are schools themselves that are involved in the ISA transactions, they call themselves schools even when they haven't become licensed or approved to operate in the state in which they're operating. That's very concerning. Also, we see that these in the ISA typical terms and conditions, typical agreements, they don't refer to students as borrowers. They refer to income share agreements as not credit, not debt, not loans. And in nearly every instance, the income share agreement itself is designed to return a profit to the investors or to the ISA company, and yet they don't call that profit interest. And unfortunately, what we're seeing is this kind of rhetoric is used to obscure the reality. And these words don't change the nature of the underlying transaction, but they do attempt to conceal it and potentially evade regulation. The bigger threat is truly that somehow the ISA industry will succeed and will conform reality to their rhetoric. And we've seen some of that with states rolling back some of their consumer protection laws to create space for the ISA industry to grow, and that is deeply concerning. So I'm looking forward to the rest of the conversation that we'll have today.
Great, thanks, Joanna. Ben, I want to just kick it back to you for a couple minutes. If you can talk a little bit about how some of the things that Joanna described, in particular, the sort of insistence that these are not loans, the people who are using them are not borrowers, what that means for state consumer protection laws, and sort of what you found in your research.
Certainly, thank you, Jillian. So I think the fundamental point that we need to keep in mind, and Joanna made this really well, is that under state law, regulators need to look to the substance of the transaction rather than how the participants in the transaction describe it. And so when we see representations, for example, and the ISAs that I've looked at, the marketing pages at the institutions that offer them, universally say this is not credit, this is not a loan. If I'm looking at that under the context of a UDAP statute, that itself is a deceptive statement if the ISA is being offered to a borrower, and I do think they're borrowers, in a state that uses a definition of loan that includes ISAs, or for that matter, in the United States, which has federal statutes that encompass ISAs as credit. So there's, I think, a great deal of potential exposure for the ISA industry, to the extent that each and every one of their products contains a misrepresentation about the nature and, by extension, the laws that are applicable to those products. That's just one example.
Great, thanks, Ben. And Kate, and I want to turn it over to you now to talk just a little bit about, sort of in your role, what factors do you all consider when you're looking at opening an investigation into violations of your state consumer protection laws?
Thanks, Jillian. Hi, everybody. I'm Kate Campbell. I am an Assistant Attorney General at the Oregon Department of Justice in the Consumer Protection section. And I enforce our state UDAP law, which Ben referenced in his intro as kind of the first category of laws that could potentially, examine potential violations of our state UDAP laws. So I'm not sure who's joining us today, but to get a little basic for those on the call, these kind of general applicable consumer protection statutes prohibit unfair and deceptive acts and practices in trade or commerce. And, there's deceptive acts, there's representations, marketing representations is a lot of what we do, like what Ben just was referencing. And some states have an ability to focus on some conduct that's unfair as well. And in general, when state AGs look at whether a particular act or practice by a company is deceptive or making misrepresentations, we look at the full conduct for everything from websites to written materials to representations that people who work, employees at these places might make to potential borrowers or students or consumers. And we look at factors, including egregiousness of conduct, harm to consumers, and that includes potential monetary losses. Whether there appears to be a pattern or practice of wrongful conduct here. And we look to see if there is another state agency or perhaps a federal agency that might be better suited to look into the issue as well. So in that sense, we do work pretty well, I think, with our state regulatory agencies. We work pretty well with our federal partners. Sometimes we all work together, but sometimes it's clear that a particular conduct might not fall within my state UDAP authority, and it might be better suited for another agency.
Great, thanks, Kate. And now we're going to turn it to Vaishali. I'm wondering, some of what the various panelists have described in terms of ISA's companies' approach to to regulation and to marketing and all of that. What are some of the risks and benefits to providers of that approach?
Thanks, Jillian. Hi, everyone. I'm Vaishali Rao. I'm a partner at the law firm Hinshaw & Culbertson in Chicago, where I lead the firm's regulatory and compliance practice within consumer financial services. And as part of my practice, I help companies either defend them in government investigations or litigation, or I help them proactively manage risk. So I would just call that compliance or risk mitigation counseling. The way I come to this topic is because I was formerly a supervising attorney or assistant attorney general in the office of the Illinois Attorney General under Lisa Madigan, where I worked on many student loan lending, enforcement, and policy initiatives, including with Ben. So I'm certainly very familiar with the issues on the table. I think the first thing is I would say, I'm not sure we can say all ISAs are created equally. So I'm not sure we could, certainly for purposes of today, we need to make some generalizations about ISAs, and I think that's perfectly acceptable. But just, I think to put it out there that there are market participants that are performing better and maybe some that are performing not so well. And so that I just want to level set that, just like with any kind of consumer product or service, you're going to see an array of market participants. So benefits, I mean, there is a lot of money to be made in the income share agreement industry, no doubt. But having said that, there's a lot of money to be made in the student loan industry in general, and I think we all know that and come to this with that perspective that there is just a lot of money in the education market. And I think when we're thinking about what products and services are appropriate to student loan borrowers or student loan participants or whatever words you want to use, and I think let's get into it later as to whether the words matter or don't matter, but the question is what's providing the best service for borrowers and what's providing the best for supporting the education system that we have. I think if we all had to do it over and start over, we might pick something different, but we are where we are. There is a massive problem in the student loan industry in general. Having worked on student loan issues for so long, I do not think it is just a lending issue. There is a problem with the education market in general, which is increasing debt for everyone. So now we sort of are where we are. The risks in the income share agreement space are exactly what everybody is articulating. The biggest risk that ISA participants are facing are regulatory risk. And I think that not all of the states are created equal. I think you all would probably be surprised about how much you differ amongst yourselves, state folks, just in general on certain terms, on certain core concepts. I think where we are all unified is in making sure that UDAP risks are appropriately reined in. And that, you know, that consumers are being given the right information and can understand the products and services. I think all the states are aligned on that topic. Certainly, you know, some of this does come down to the wording that folks are sort of dealing with in their own particular state. So I don't even necessarily think some of it is a policy difference. Some of it is just like you have to live with the words that are in your own state statutes. But there is that room for sort of different interpretations among different states. So I think industry participants, at least like I said, sort of, maybe we'll say the good industry participants, and I think we've heard this before, they would certainly suggest that they are not opposed to regulation. But what they would prefer is regulation that fits their product and service, and that sort of makes a recognition about what it is that will work for the setup of their product and service. So I'm very happy to be here. I really thank you for allowing me to participate. I'm more than happy to sort of dive in and share perspectives.
Great, thank you. And Rodrigo, I now want to turn it to you. And you're coming from an interesting perspective, and I'd love for you to just share that a little bit. So can you tell us a little bit about how your office is thinking of ISAs in the context of Illinois' recent efforts on student finance?
Sure, and good afternoon. It's a pleasure to be here this afternoon. So as the Deputy State Treasurer and Chief Investment Officer at the Illinois State Treasury, one of my many roles is to diligently invest the state's assets, approximately $32 billion or so. And this includes several investment vehicles to assist constituents in pursuing a broad range of financial and investment goals. In the education sphere, we have 2 highly rated college savings plans. We are in the midst of implementing child savings accounts, also known as baby bonds, to further provide financial support for Illinois residents. And we are also diligently working on the upcoming student investment account, which I will talk about here shortly. You know, we became interested in ISAs through our work developing the student investment account, which passed in late 2019 and allows, but does not require, the treasurer to invest approximately $800 million on a recurring basis in student financing products, whether they be new loans being issued for college completion, refinancing of expensive student loans, and or ISAs. So this platform is being developed with the lower to middle income student in mind, who has run out of finance or student financing options to continue and finish their education. As it currently stands, non-citizens can't access federal loans, and the private student loan market is not a friendly space for most students, where APRs can range as high as almost 15%. Some students don't qualify for private student loans either, and they may not have a cosigner available. So we can't influence tuition costs because we're not necessarily in the education sphere itself, but we can ensure students finish their degrees and benefit from increased lifetime earnings. The way that we think about ISAs is that there is a difference between the product itself and the market participants who may be acting in misleading or non-compliant ways. We are seeing similar types of predatory behavior that exist in student loans. As we consider entering the market, because again, it's not guaranteed that we will, we would obviously only invest in products that adhere to existing licensing, regulatory, as well as consumer protections at a minimum. If not much more than that, just given the predatory behavior that has existed in the student loan market. You know, we are approaching this topic while centering consumer protections and remaining cognizant of existing racial, ethnic, and economic inequities, and how this is already causing disparate impacts in education financing. And so this initiative or this platform is in line with proposed legislation and regulatory actions that currently exist here in Illinois, whether that be the Illinois Student Loan Bill of Rights Act, whether it's the existing lawsuit against Navient by the Office of the Illinois Attorney General, whether it's the proposed legislative bills that are currently awaiting consideration, especially in light of the pandemic. More than likely, this won't come up again until 2021. But there are amendments to the Debt Settlement Consumer Protection Act. There's proposed legislation around Know Before You Owe Private Education Loan Act, as well as proposed legislation around income sharing agreements, which I can get into further detail as we have further discussion. But ultimately, all these work towards enhanced protections and disclosures. Now, for further background, in a previous role as chairman of the board for Student Veterans of America, I was involved in spearheading several initiatives for almost a decade, where we not only helped pass the post 9/11 GI Bill, which provided nearly $60 billion for returning service members who were coming home from Iraq and Afghanistan, but also some of our work included safeguarding and protecting veterans and military families from predatory practices that arose from such issues such as the 90-10 rule or the gainful employment rule. So I do have experience in addressing predatory practices and behaviors. So with all of that said, I look forward to the additional dialogue today, but also not even only today, but also in the next several weeks and months as we evaluate the role of ISAs within our portfolio, a portfolio whose intent is to help, not harm Illinois students and residents. And if we can't do that effectively, then that will be the determining factor.
Great, thanks. Rodrigo, I'm wondering actually if we can follow up with you a little bit. you know, as a potential market participant, and like you said, there's no guarantee that you guys are going to do this, but you know, what do you think in terms of the way that existing laws and regulations pertain to ISAs? I mean, like what we have on the book so far regarding student loans and consumer finance, how do you feel those apply?
Yeah, I think they do apply. And I think the scholarship and the analysis that has been done to date by not only by the Student Borrower Protection Center, but a number of other stakeholders have, provide that substantive and substantial evidence. Student financing at the end of the day is a high risk field. We're talking about contracts, whether they be traditional student loans or ISAs, are contracts that students sign when they're as young as 18 years old. And so as a result, we know that some of these can often lead or can be predatory and lead to predatory behaviors, even with existing consumer protections and regulations. That said, there are pieces of ISAs that would benefit from additional regulatory clarity, such as the disclosure about variable effective APR, what constitutes a payment versus a deferment, how to handle in bankruptcy, et cetera, et cetera. But at least it is our perspective that when it comes to ISAs, some of the existing consumer protection laws do apply. But in certain areas where there may be areas of gray, I do think that there could be additional regulatory clarity, whether it's under the existing structure or under new statutes, in order to make it even more clear. Because ultimately, at least it is our view that students, we have to have what's best in the interest of students in terms of their future potential, but also even more so is to ensure that they're being provided with all the information and protections to ensure that they're not being subject to any type of predatory behavior or practices.
Great, thank you. And a reminder, if people want to ask questions, they can email walter@protectborrowers.org. So I wanted to circle back to something that Vaishali brought up, which is, there's a lot of, it may vary in terms of how different states are approaching these products. And so I'm wondering, maybe Ben can start, but if anyone wants to jump in, kind of what is the range in the landscape surrounding, in different states surrounding, with laws surrounding these products? Like sort of, what are we dealing with here?
So I think I kind of sketched out the different types of specific consumer loan regulations, but I think we're dealing with actually a pretty consistent baseline in terms of the application of UDAP statutes. There's a little bit of variation, but for the most part, it's quite similar. So I think there should be an opportunity for state regulators to oversee those. I think there's also an opportunity for state departments of financial institutions, departments of banking to talk with one another, particularly amongst states that have similar statutory language, and come up with a way to address some of these issues. For example, I think, Rodrigo mentioned the APR issues, and that's something that we don't see disclosed or represented to consumers, and again, a lot of the time, not particularly, financially sophisticated consumers because they're young. And it makes it really difficult to compare those from a consumer standpoint. And frankly, it makes it really easy to hide sort of what I would characterize as the upside risk to ISAs from a student standpoint. So the fundamental deal with the ISA is in exchange for the potential that you complete your contract without having repaid the amount nominally financed. is that you make a payment that might end up, with an effective APR in the 20s or higher, and without that information, I think students are going to have a really hard time making an informed choice about what financial product is best for them and their and their education and their own financial situation. So.
Yeah, I see Joanna. Go ahead, jump in.
Yeah, I'd be happy to build off of that and offer that there's another set of regulators that I want to tag into this conversation, and that's the regulators of higher education.
Wait, I thought you said it was working.
And so in every state, there are regulators who oversee proprietary schools and also institutions of higher education. And in some states, those types of schools are carved out of crucial general consumer protection statutes. And in some instances, the financial products, the institutional loans that are made by schools are under the purview of other agencies. So it's important to be in conversation with them, in particular because we're seeing ISAs not just in higher ed, but also elsewhere. So when we're thinking about ISAs in general, we should also be thinking about any risks that ISAs pose to consumers outside of higher ed, and be looking for rules that we can, that make sense for ISAs as a product wherever they crop up. And that's one of the things where historically we think about treating students differently, we think about student loans differently, and sometimes that's to the detriment of students. And we have to be really careful here that when we've got our higher ed policy hats on, we're not looking at access as a driver to promote products that might present unnecessary risk for students. Higher education should be accessible without regard to ability to repay. And yes, our current system of financing higher education is incredibly broken. I'm really sorry we're not having a conversation about debt-free college. I envision a world in which we don't have student debt anymore. And I'm sorry that we have to spend so much time thinking about new debt products for students. But it's important that we make sure that all of the regulators who have a role to play are also tagged into this conversation, because unfortunately, our institutions of higher education are sometimes carved out of generally consumer protection statutes of general applicability.
Great. Anyone else want to jump in, or we're good? Okay. So one thing I wanted to ask about that I think a couple of people have brought up is this idea of regulatory clarity. And I'm wondering if someone can just expand a little bit on that. I mean, why are providers interested in regulatory clarity? And then also, why is it important for students or consumers? And are we talking about the same thing? Is one version of regulatory clarity better for consumers and students and one better for the industry? So any thoughts on that? Great, Vaishali, go ahead.
Yeah, honesty, I'm not sure I appreciated when I was on regulator side, how expensive it is to comply with lots of state laws. I really did think that was kind of an illusory argument on the part of industry. I've now learned how expensive it is and what that can mean for an ability for a company to operate effectively and to also produce and really, when you're taking money and putting it into only just pure, like, can I just check the boxes off of 50 different states plus a federal government, and as Joanna rightly pointed out, even maybe a multitude of layers of different kinds of agencies, it's just money that doesn't go into thinking creatively about doing what's best for borrowers. And so I'm not suggesting it's a one or the other, right? But I'm just going to give the example of the state servicing laws that even, the servicers right now struggle to figure out how to operationalize consistently across states. And so when you have to put a lot of triggers in place in actual systems to, and I'm really talking nitty gritty, like in your software systems to flag for different items, that can be very expensive. You have to build out separate products to do that, and you have to get with the right vendors that I'm not sure are catching all the right issues. One of the things that I think can be exciting about income share agreements is the ability to start afresh with the inclusivity of some consumer protections that were not considered in sort of the days of creating the student loan market that we know today. And so I think maybe it was Rodrigo who pointed it out. I mean, I just think what income share participants would say is borrowers don't know what they're getting on a student loan to start with. So I think that's not to point fingers at one industry or another. That's to say that whatever the disclosure regime is that we have right now, and we all know it, like we all see a promissory note, and we all know nobody can understand a promissory note as it's written and as it's drafted. It's in federal regulation and part of it, right? So again, it's not a pointing finger situation. It's just when we really think about where we are and what people can understand in this marketplace, I'm not sure just starting with plugging in income share into existing structure really advances the ball. And so the part that excites me about conversations with regulators, and I think the part that even market participants would say is the exciting part about having conversations with regulators, even though maybe they wouldn't use the word exciting, is the conversation about how to move the ball and how to make disclosures that fit and that make sense. And I'll just say this, I think, Ben, your point about comparisons is a very good one, that, you know, somehow you have to be able to see, I don't know if you'll ever get apples to apples, but you'll have to be able to like see the whole fruit basket and be able to at least compare products and services appropriately. But again, I'm just kind of throwing out there that right now, if you ask any person who's looking to get financing on higher education, whether they understood the difference between a PLUS loan, a private loan, you know, any other kind of product, I'm not sure they'd be able to articulate it. And so when we're talking about choices and comparisons, I think we need to be talking about the marketplace as a whole and thinking about how we might be able to improve upon that and the opportunities that we have to do that in this sector.
Great, thank you. Okay, we're gonna take a 2-minute pause, but I see Joanna and Ben hold your thoughts and I will try to remind you of them when we return. So we were talking before about regulatory clarity, and you know, it's something that market participants bring up, and it's also something that is a concern of consumer advocates. And so, you know, we were discussing whether they're sort of talking about the same thing, and if there's certain types of regulatory clarity that are better for market participants or better for consumers. And so I know that Ben and Joanna had wanted to jump in. So maybe Joanna, if you're ready.
Sure. I just wanted to offer, I think this question about where clarity helps or hurts and who it helps or hurts, who it serves, is really important. But what sticks out in my mind is that even where the law is clear right now, we don't see this industry complying. So clarity isn't the problem. And unfortunately, that means that we can't legislate or regulate our way to a solution to the problems that the ISA industry presents. So states should go forth and issue guidance to the extent that the industry is asking for instructions, issue guidance. But also, don't wait to intensively supervise, ask for information. This is an industry that suffers from a lack of transparency, and these products are confusing, unnecessarily so. So go forth and supervise. Also, enforcement actions are necessary. And whether there are new regulations that are ISA specific, whether they're new statutes that are ISA specific or not, consumers can't afford to wait, and enforcement will be necessary. So, so it's important to go ahead and operate accordingly. And unfortunately, because we're still in this world of a broken higher ed finance system, and we're still dealing with federal student loans, private student loans in a kind of a wild market, where ISAs are introducing unnecessary confusion, but also want to compete with private loans, it's really, when we think about how much variation there is from state to state, as far as the regulatory landscape, that's a feature of our federal system. States get to protect their residents, they get to choose how. That's important, and it's critical, it's at the heart of our consumer protection framework, and that's historical. It's not new, it's not an accident, it's on purpose. So we've asked other products, including traditional private student loans, to follow the laws of the various states, and they've had to comply. The burden that the ISA industry faces isn't different from the burden on their competitors. So why should they get better rules, more favorable rules? And the consumer protection rules that we have right now are designed to protect consumers because of problems that we've observed in industries like the private student loan industry that we've gotten to see and observe and learn from over the years. So the other piece of this is that even where there are uniform statutes, there are uniform rules that apply, where we have federal law, and states, a lot of states incorporate federal law into them. So it might be a UDAP violation in a certain state if you don't follow federal law, for instance. So when it comes to income share agreements, the fact that they don't use TILA terms, the Truth in Lending Act prescribes certain terminology that financial products are supposed to use. And the fact that the industry eschews that terminology, the basis of all financial literacy training, the reason why we say, when you disclose terms, you must disclose terms and you must use these words, that's so that consumers can comparison shop, so that they will know what kind of products they're looking at. And this industry flatly refuses to use those defined terms. And those are uniform terms. They don't vary from state to state. That's at the federal level, and they don't comply with that. So that's just one example of where what this industry is asking for is unreasonable and harmful to consumers in ways that are completely unnecessary. We've got a framework, we've got terms, we've got a glossary, and we've asked consumers to learn that glossary, and yet this product is confusing because even the terms are different. And that is not the features of the product, but the language. So yes, the words matter, and this is one of those places where uniformity and clarity can't solve the problem that the industry is presenting.
Anyone else want to jump in? Okay. I'm wondering too, and maybe Joanna, you're best suited to answer this, but also if anyone else wants to jump in too. Right now we've kind of been talking about at the level of the product, the kinds of things that they're asking for, what regulators might want to do. And I'm wondering if anybody, if that's all kind of theoretical for now, or if we've actually heard complaints about it. I know last week, someone from the Pennsylvania Attorney General's office said that, they were sort of looking at this, but hadn't really received complaints about it yet. And so I'm wondering, Joanna, maybe in your role as an attorney, or, anybody else, what they've heard.
I'm happy to dive in first and say that one of the services that we offer at the National Consumer Law Center is we provide technical assistance and intake support to legal aid programs and consumer attorneys whenever they face tricky problems. And unfortunately, we have been hearing from attorneys and advocates in the field who are working with ISA borrowers who have questions. And those have come up in, I was trying to count the states, but I think at least 5 different states and probably at least 7 or 8 different schools have been implicated at this point. Or no, I got that backwards, 7 or 8 different schools in 5 different states. Unfortunately, because of the nature of the income share agreement product and the way that it's disclosed, it's often not until the student has an issue with the quality of the program or their experience in the program, which is way after they've signed their ISA contract, or after the student enters repayment, that they start to look at the features of the product and what that really means for their life. So these advocates who've reached out to NCLC have been working with borrowers who are who have concerns about the onerous requirements to submit income documentation, even where the borrower didn't get the benefit of the education. And often one of the things that we see is borrowers who get kicked out of their program, who aren't able to complete for any reason, are still on the hook for repaying the whole income share agreement contract, which just doesn't make sense. We've got refund policies and other things to protect students from being on the hook for the price of a whole degree when they don't get a whole credential in other contexts. And then also there are borrowers who got the job that they were training for without getting the benefit of the education, or who are now looking at that slice of their income, whether it's 17% or something, and that's just not affordable for them. So those are the kinds of things that advocates have been coming with us about. And we're encouraging these borrowers to contact their state regulators. And I think their overarching question is, what will my state regulator do if I contact them? And also, is it safe for me to contact them? I will note that when we see certain products, income share agreement products that are targeted towards vulnerable communities, including low-income students, but especially immigrant students, there are some concerns about potential immigration consequences when making a complaint to a state agency, without knowing whether there will be a positive outcome, or whether there will be a benefit for that borrower. So we're helping advocates sort through all of that, and we're helping them understand the state laws that each particular ISA should be complying with as they're evaluating their options for assisting those borrowers.
Great. I see Ben, you have a thought, you want to jump in?
Yeah, I think what Joanna just said really highlighted the importance of agencies both within a state and between states really talking about this, because, for example, an attorney general's office might not get a complaint about the quality of the program or the way in which an ISA was marketed or entered into. That could come to a couple different regulators, whether a financial regulator, whether it's the agency that regulates degree granting institutions, or the agency that regulates non-degree granting institutions. And that could also come in to sort of numerous states as well, if the borrower isn't located in the same state as the school. So just as the regulation of these products requires input from, attorneys general, from financial regulators, and I think maybe even most critically from educational regulators, the detection, the analysis, and the aggregation of, consumer complaints and consumer issues really has to be multifaceted to deal with this problem.
Great. Yeah, Kate, I see you have a thought too.
Yeah, so this would just be my plug to the participants viewing the call who might sit in an AG office or who might work at a state regulatory agency to get to know one another. Some of my most valued relationships right now are those with my higher ed agency folks and our Division of Financial Regulation. And we're able to more easily share topics that we know we're interested in and complaints quickly if we see something. Also, I can't answer, I don't think I can give a sufficient answer to an advocate who says, well, what's going to happen if I submit a complaint to this state regulator? But I would nonetheless encourage folks to submit any consumer complaint, not only to their state regulator, but their state AG office, knowing that, if anything, that's educating staff on issues and helping folks learn how to issue spot and what questions to ask next.
Great. Yeah, Vaishali.
Sorry, I gotta unmute myself. I just was reflecting, so maybe a teeny shift in the conversation, but kind of back to what Joanna said. And, I can't comment on why or what the intentions are of every market participant. I would just say, I don't know that the lack of wanting to use the word or trigger for APR I think is more complicated than just wanting to blow it off or not. And I'm not commenting on specific market participants, but I think, you know, when you really drill down into TILA and when you look at open-end credit disclosure requirements and the ways in which APRs need to be calculated, they are tied to some concepts that don't have a clear port over. And I think that although they could, here's what I'm saying. I think it's open for interpretation as to whether you should or shouldn't use them. And I guess all I'm saying, and like by an example, I mean, the words that are used in the open-end credit sections of TILA trigger to billing cycles, trigger to periodic statements, and calculating time periods when borrowers owe money. And it's just, it is a different system. Now, whether, if we want those to apply, and I'm kind of neutral as to whether we think they should apply. I think I understand the value in there are already existing words that consumers have had to digest and that industries had to digest, and maybe an APR comparison is the right thing to do. I guess all I'm saying is if we wanted those to apply, we do need to legislate on that. I mean, or regulate in some way, shape, or form. I don't think just because what industry is going to have a hard time doing, I'm not saying they won't do it, but is going to have a hard time doing is just listening to the loudest voice and saying, well, such and such entity, regulator, what in one state thinks that APR should apply. It's hard to make a decision just based on that. It's you know, they have to kind of look at how that might ripple implications for them in other disclosure contexts as well, and whether those disclosures actually make sense for them. And so that's why I think they're actually encouraging federal legislation on coming up with a system that makes sense to them. And maybe that does incorporate some of the existing principles, but puts a clearer fine point on how those terms should be interpreted in the context of income share agreements.
Great. Yeah. So I'm wondering, you know, you mentioned, Vaishali, the sort of what's going on at the federal government level. And I'm wondering if people can talk a little bit about the interaction between regulating at the federal government level on these issues, what's going on in states. I know, you know, sort of in the student loan industry broadly, there's been a battle between the federal government, states, companies, about who has the responsibility to regulate. And so I'm wondering, you know, first of all, you know, anybody who's interested, if they can lay out the landscape of that. And then second of all, you know, sort of what that conversation means both for consumers and for industry. Oh, Joanna, go ahead.
So we've been watching bills that have been introduced at the federal level since maybe 2014. And there have been a number of different iterations. From a consumer protection standpoint, each of them is a non-starter. And I can walk through a lot of reasons why. At the state level, we've also seen more activity. Many of the bills that have been introduced have been industry-led, but we're seeing some bills that are more of a consumer protection first variety. And that is, I think if we're gonna see legislation on income share agreements, then it needs to be really couched in the existing consumer protection framework rather than seeking to peel that away or roll it back. Unfortunately, for consumers and for just the state of where things are at the ISA market, the bills at the federal level really would eviscerate the consumer protection framework in some key ways. And where they wouldn't do harm, they wouldn't do good because they don't actually change the way the existing framework applies. They just say, oh yeah, the framework applies. And then they pull back, kind of seek rollbacks of the protections in the existing framework that they don't want to comply with. To be very concrete about this, and also to connect the federal, what's happening at the federal level to what's happening in the states, I just want to point out some of the provisions that are in the existing federal bill. This is a Senate bill. It is entitled the ISA Student Protection Act of 2019. And right off the bat, one of the biggest concerns from a consumer protection standpoint is that it would preempt crucial state laws that are designed to protect consumers. It would preempt existing state laws about ability to repay and licensing or registration that don't specifically target ISAs. So any existing laws of general applicability on those fronts would completely be gone. They'd require states to re-regulate. That's a lot of work to shift to the states, where states have already made some decisions about what they want to do with consumer credit. They'd also preempt existing state laws on usury and any future usury laws that those states might pass that don't specifically target ISAs. So again, they're asking states to treat ISAs differently. They're saying, erase all the laws you have on the books, if you want, you can create a new framework that applies to ISAs and only ISAs. And that is deeply troubling. Usury and the ability to impose interest rate caps is something that it happens at the state level and is an incredibly important feature of the systems by which states protect their residents from predatory lending. See the payday lending industry, where some states have strong rate caps and are able to keep that industry at bay, whereas others haven't imposed such strong caps, and we see triple-digit interest rates that harm borrowers and keep them in debt for a long time. Also troubling, the federal bill would preempt state laws regarding legality of contracts and wage assignments. So essentially, the ISA industry envisions a world in which these ISAs could essentially be repaid through wage garnishment, so that a portion of your income goes straight to the ISA lender before it goes home with the borrower to pay for their heating, for their air conditioner, for the roof over their head, and for the food that they need to feed their families. And an additional way that this bill would preempt state law is that it would preempt both federal and state laws that apply to prepayment penalties, such that a borrower who gets a job and repays their ISA really quickly and incurs and has to pay extra, essentially, because that's how these contracts are designed, that would not be considered a prepayment penalty. But nonetheless, that is exactly how the consumer would experience it. And those are just some provisions, some core provisions that would preempt state law and do violence to the existing ways that states protect their residents. There are a lot of ways in which the fabric of our federal regulatory system would also be torn asunder by this bill, including carving some of the things that were talked about last week when it comes to credit discrimination, and defining the business model that most ISAs use as not discrimination for purposes of the Equal Credit Opportunity Act. So for a lot of reasons, those are just a few. I have a long list. There are deep concerns with the kind of legislation that's been proposed at the federal legislation. And as consumer advocates, we simply see no path forward with the existing bills that have been offered. I'd be happy, I've been talking for a while, so I'm going to cut myself off, but could also walk through some of the state bills and particularly the bill in Illinois that did take a much more consumer protection stance. These bills are night and day, in case anyone wants to go home and do their own analysis. If you want to see a piece of consumer protection legislation, look to Illinois. If you want to see an industry-led bill, look to the federal bill.
Okay, thanks, Joanna. I see, okay, Vaishali and Ben. Vaishali, do you want to jump in? Or did you? Sorry, okay, no problem. Ben, did you want to jump in?
No, that's okay. If you wanted to segue to another.
Okay, great. I guess also, we just talked a little bit about Illinois, and I'm wondering if I can just turn to Rodrigo for a second and This question, I think we'll start with him, but then if people, want to jump in more generally too, that would be great. And so, Rodrigo, as you guys are, thinking about the possibility of entering the ISA market, what kinds of consumer protections are you focused on ensuring that this product would have? And then I guess kind of the broader question for others is it possible, to create a consumer-friendly ISA? We talked a lot about kind of there's a range in products, a range in regulations. So those are my questions. So let's go to Rodrigo first.
Excellent. Well, first, thank you, Joanna, for the shout out to the state of Illinois. I think that there are a number of stakeholders here within state government who are trying to coalesce around that additional clarity and to ensure that consumers are protected from any income sharing agreements here in the state of Illinois. And some of those key components that are part of that bill, before I transition and segue into the second part of my verbiage, is clear disclosures with certain specified timeline, disclosure in terms of the APR under various specified scenarios, monthly statements, the agreement cannot necessarily be for more than 5% of borrower income, provides for term length not to exceed 60 months. There's a cap in terms of the repayment amount. There's a number of other provisions specifically around when the payment standard can begin, around deceptive practices, and then also that in this case, a student must exhaust all federal loans and state grants available to ensure that those that have, or at least traditionally have had, much more consumer-friendly focused efforts are first utilized before some of these other products are consumed by potential students. So in our opinion, all these work towards enhanced protections and disclosures. Now, with that said, there's a paradigm that I want to also introduce into the discussion, because there is one way, which is to regulate those service providers that are trying to maximize the investment for ultimately are the investors. We believe we can also enter the market from that side, from the investor side, and really set the tone and the benchmark for what is to be expected for a consumer-friendly student finance product. Ultimately, in our opinion, the things that we are going to weigh whether we enter the ISA market is consumer protection. Is any product that we invest in, we would need it for that service provider to abide by all existing licensing requirements and consumer protection regulations at a minimum. We do not see a reason to provide exceptions on this emerging product. We will hold any of our partners to the same standard that we hold the rest of any other traditional student loan service provider that has offerings to. Number two is the disparate impact. We are keenly aware of the potential for harm that a predatory product could have on segments of the population that already face all sorts of systemic barriers and challenges, specifically around African American and Latino communities. So as we think about the aspects of this program, but most importantly, ISAs, we want to be assured that we don't push a product that is just continuing to exacerbate the systemic and historical issues that have plagued these communities. Number three is economic equity. When applied correctly, the levers against economic uncertainty can help prevent an avalanche of financial distress. And so ultimately, can this product help achieve economic equity, especially when compared against traditional student loans? Number four is the lack of opportunity. Another thing that we continue to see is students who can't access federal student loans, either because they're undocumented or for any other reason, or maybe that need small amounts of gap financing in order to complete their studies. What is better served? Is it a traditional student loan, especially one that is backed by us, or is it one that is an income sharing agreement? That is ultimately the question that we're going to try to answer, at least for us, over the next several months, as we try not only to establish the regulatory regime, but also what is it that service providers and who are they catering to, which is on the other side, the investors. And we hope to establish, using our market position, especially given the size of our potential investment, the ability to create a state-focused ISA that sets the benchmark for other ISAs to follow should we enter the market. That will allow us to set and raise the bar for everyone else. And if we don't believe we can do that, then that will probably be the determining factor.
Okay, I see Vaishali has a thought.
Okay, I'm gonna try to do it quick for you. One, very proud of Rodrigo's work in Illinois. I'm always proud of my home state and their emphasis on consumer protection. I just want to kind of offer by way of comparison that most state governments are involved on the investor side in the higher education space, including in Illinois. The way that they had traditionally invested was in a private student loan program, and wage garnishment was used at extremely high levels. So I offer that as a tool for comparison, because one of the reasons why people like Rodrigo on state side are invested in this kind of a product is because it offers a better solution to what they were doing previously, especially as it affects Black and brown borrowers. And the other thing I would say, again, work that's been done even out of this the center that's hosting this panel today, is that one of the challenges in any open-end product, especially with respect to private student loans, is that the product is inherently reliant on discriminatory systems of credit reporting. And so there are, I think, things that can be changed and equalized if income share agreements are used adequately and properly, that have been historical systemic problems in open-end credit products, specifically with respect to student loans where you really have no credit history. And especially we know for a fact that Black and brown borrowers often have worse credit history when they're younger adults and when they hit 18 than do white borrowers. Or even you could take that to socioeconomic status too. So I think this can be a game changer if it's used in the ways that Rodrigo is talking about. But what I don't want to see happen is we throw the baby out with the bathwater, that we sort of peg it as either a good product or bad product. I think there's a lot of different variations, and we need to work on making sure they're as effective as possible.
All right, and Joanna's just going to jump in real quick, and then I think that's all the time we have.
Thanks. I just wanted to offer that I think setting a benchmark and guiding the industry, that kind of guidance, that kind of example is necessary, because at this point we don't see any consumer-friendly ISAs on the market. And when I say consumer-friendly, that's particularly because of the ways in which there are no products that currently follow existing law. And when it comes to TILA terms, whether it's disclosing an amount advanced, whether it's disclosing interest as interest, we don't see products that do that. Even the products that have the most favorable terms for consumers continue to violate existing consumer protection law, and that's a problem. So I would welcome market entrants who actually follow the law and show the rest of the industry what good behavior looks like and how consumers should be treated. And I just wanted to highlight that we've talked about a lot of the ways in which regulators can play a role, and all the different regulators who can play a role, and public enforcement is vital, especially where a lot of the kinds of harms to consumers are hard for those consumers to perceive on the front end. The other reason why public enforcement is so necessary is because private enforcement is difficult, and that includes difficulty because arbitration clauses and class action bans are typical features of the template ISA contracts on the market right now. That means that students and borrowers who run into problems with their school or with their ISA product will have difficulty clearing the first hurdle just so they can get heard in court. So it's really important that we have other eyes on this market because an arbitration clause won't prevent a state regulator from reining in a predatory product or actor. So, so this is me making the case for states, as you regulate, to please regulate, take necessary enforcement actions, and also as you think about the framework that should exist for ISAs, look to see that actors aren't being consumer unfriendly just by imposing mandatory arbitration on potential disputes at the front end. So, so I just wanted to mention that public enforcement is essential, and we need to open the door to private enforcement in this industry as well, because we're seeing bad practices, and it will take all of us to make sure that those practices don't proliferate in this industry. Thanks.
All right, well, thank you. Thanks, everybody. I think that's all the time we have, but thanks so much for joining us.